Hello and welcome to another installment of the Osgoode Mediation Clinic's newest series called Mediator Spotlight. I'm Melissa.
And I'm Phoebe, and we're both law students at Osgoode Hall Law School and community mediators at the Osgoode Mediation Clinic.
In this online series, we will be chatting with practicing mediators about mediation generally, their unique career paths, and their experiences with the mediation process. Through these interviews, we hope to bring greater awareness about alternative dispute resolution and mediation specifically to our community.
Without further ado, we'd like to introduce our guest, Mr. Leslie Dizgun. Leslie is a mediator and arbitrator with 27 years of experience in dispute resolution. His areas of expertise include commercial disputes, contracts, wrongful dismissal, workplace, franchise, real estate, and construction matters. He's a frequent speaker and instructor on ADR and dispute resolution topics, and he's also an adjunct professor at Osgoode Hall Law School teaching dispute resolution in the civil justice system. He also taught civil procedure, dispute resolution, and administration of justice.
So welcome, and thank you so much for joining us tonight. We're going to start off with a question, a kind of a reflective question. So as a law student, did you see yourself becoming a mediator, and what drew you to mediation?
So the answer would be no, but I went to Osgoode from 1983 to 1986, where if I've got this correct, there was no pilot project for mandatory mediation in the justice system, civil justice system, and there was pretty much nothing about mediation at Osgoode. I think there might have been a course on negotiation, but I don't believe there was anything being taught about mediation. And so it was just not even surfacing at that point, really, in terms of law school. So, I mean, maybe I should tell you how I got involved in mediation. So I started practicing in 1988. I actually, I had this, every 5 years, I thought I needed to do something else with my career. So I would always look around and see if there's something interesting to do. And I started reading about mediation. And actually what I did is I went down to Harvard Law School and did their mediation workshop. And coincidentally, around the same time or within that same time period, Paul Emond, who was a professor at Osgoode, was looking into, with some other people, developing a LLM in ADR. And I knew Paul from law school, I think, and from other things. And he invited me to join a kind of steering committee to develop the master's degree in ADR. So I got involved in that, and then a few days before the applications closed, I applied for the part-time LLM in ADR. So that's how I really got involved in mediation. And then secondly, in that same time period, I can't remember whether it was 98 or 99, but someone can check, but the Attorney General's office and the Ontario government decided to do a pilot project in mediation for the court system in Toronto. And I volunteered to do mediations for free in the pilot project. They hired 2 or 3 people full-time and so on, but I did, and a couple other colleagues that I knew, we did mediations for free at the Grenville pilot project. And so that's how I started doing mediation, in fact. So that's how I got involved.
That's great. So we read that you mediate disputes in a variety of practice areas. Would you be able to speak a little bit more about those practice areas, and do you have a main practice area of practice today?
So my own practice is employment law and commercial litigation in terms of the litigation practice. And I've developed some subject matter expertise aside from that in franchise matters and in condominium matters. Condominium matters because I lived in condominiums and just it's a personal experience. But I do a fair amount of condominium related disputes. I off and on I do franchise disputes, and then the large majority of the other disputes I do in mediation are essentially corporate commercial. So they're either shareholder remedies, shareholder disputes, breach of contract, real estate related breaches of contract. And in all of them, there may be elements of lawyer's negligence or something else, but they're all within the context of, I even think of employment law as really corporate commercial litigation in some ways. So so it's really the gamut of commercial matters that I do. I don't do any personal injury. I don't do any family. And I do some arbitration in commercial disputes.
Awesome. So we would love to know a little bit more as well about your mediation style. So as students, we're always trained about using kind of a rather formal method of mediation that has, very clear, distinct phases. So do you stick to a more structured method, or do you take a more informal or conversational approach?
So I think that, and I saw that question in advance, so I thought about it. I think you have to understand that, and I teach negotiation and mediation at the school, and I teach initially interest-based Harvard kind of model of principled negotiation, and I still accept that. That is, I still do, I think, a kind of principled criteria negotiation, but the way what the civil justice system has done is really generated a kind of institutional mediation, right? So typically it's either 3 hours long, which is the standard mandatory mediation, or a day. People either book a half day or a day. And for sure in a half day, you can't contract in because everybody's contracted in anyway because it's mandatory. You really don't get, most of us now don't have opening statements. So we have plenaries that last 5 or 10 minutes where we talk about what mediation is about and what we'd like to think the objectives are. And then really it's kind of shuttle diplomacy. We really go from room to room, and we're dealing with the lawyers as much as the clients. So it's quite different than your classical model of mediation when it comes right down to it. And it certainly, at the same time, swings from more facilitative, that is oriented to what's going on in the litigants' minds, what's motivating them, but also quite evaluative, because frankly, lawyers don't hire you unless they think you have some subject matter expertise, and I think as well some subject matter expertise in the litigation process, right? Like you can't escape cost shifting when you're talking about settling cases, because even if you do it on a risk analysis, part of the risk is the cost you might pay the other side if you lose, and so on. So the objective criteria that often gets used is the legal environment, not necessarily case precedent, but the legal environment, and in part what a judge may decide, what the risks are in light of that, and so on. Other mediations are much more business oriented. They're much more about finding some kind of business solution to the problem, and sometimes the issue of case precedent or the kind of evidence that's going to be led, most of which is contradicted by the other side in any event. So, if you have two opposing narratives, right? I tend to try to avoid all of that, because I'm not there to decide, and I'm certainly not in a position to know what's true or untrue. So that really doesn't get engaged, somewhat ironically, since people start the process by thinking that somehow they're going to get vindicated by a judge. right? Judge's going to find in their favor and against the other party. But in fact, really, I turn it all upside down, all around, and that's not the way I come at a problem.
Right. So our next question is, what is the most common misconception that people have about mediation before they actually participate in it? And you can speak to the perspective from a client or a lawyer.
So I think really it's the clients. I think lawyers pretty much have now had enough exposure that they don't have many misconceptions about the process. And if they're hiring you, they probably had a mediation with you before in many cases. So it's really the clients, I think, who to some degree, I think, implicitly think that you're going to be somehow, quote unquote, deciding in the context of a mediation. Sometimes like they want you to be on their side, right? They want you to agree with them. So there is that misconception. On the other hand, they tend to give you a fair amount of almost instant credibility because they kind of see you as a quasi court officer, even though it's a private mediation. And I certainly respect that and respect that they think of you that way. So it's important to, I think, to be somewhat empathetic in terms of their experience, to be seen to be relatively fair and impartial, and not necessarily neutral.
Right. And do you address those concerns at the beginning of the mediation and kind of hope that their concerns are addressed?
I mean, I do an opening where I say that, I'm here to assist them in resolving their dispute. That's my goal. I also say, but often now, that cases don't settle unless people compromise, because as much as we think that, there's a notional win-win solution, the reality of litigation is that people generally don't settle unless there's a compromise. If one party isn't compromising, there's no groundwork, there's no basis for a settlement. And then I tell them a little bit about how I do it. And then, one of the issues becomes whether we do offer, counteroffer, right? Well, I don't like doing that. So I tend to talk to people. I go back and forth and talk to them. And I try to get them privately within a range where I think there's a more probability of settlement. And so if there is an offer or counteroffer, it comes some way down the road. So I think an offer, counteroffer out of the blue is a waste of time. And, I can start at 5 million and you can start at $1, right? And we can waste a whole lot of time, getting to 100,000 when they think their claim is worth 2 million originally. So I like to talk to each party and their lawyer and challenge them on their positions in the case and what they want out of it. And sort of ultimately, if we talk about numbers, then I try to see what range they're in and what range the other party in. And if I think I've got them closer, even if it's still far apart, then I might say, okay, maybe one of you should make an offer, right? So you can see it's a bit different than the classical approach to mediation.
Yeah. And what do you find to be the most challenging part about mediation? So especially perhaps in the virtual world we live in today.
So I have found virtual mediation to be pretty good, frankly. I think the only thing it lacks is one of the things I think facilitates resolution is a certain degree of rapport that the mediator has to have with the parties and their lawyers. It's funny how mood impacts resolution. Like if I came in and I wasn't in a good mood, I can guarantee you that would impact things, and I don't know why. So I come in and I'm relatively optimistic, right? I try to generate the fact that no matter how difficult the case is, I'm optimistic about the possibility of resolution. And I think that you need to develop some rapport with the parties. So in person, that's easier to do, right? Obviously, because you're there in the flesh, they see you, they engage with you, there's body language. And so if anything, virtual mediation kind of strips the mediation of that component, right? And to that degree, the lawyer can have somewhat greater control of the process, right? Because it's hard to reach the client through the lawyer. And not that I think lawyers are obstructive, but I think sometimes it's good to connect with the client as well. So I think that's the real drawback in virtual as opposed to in person. And I don't think that my rate of settlement is really altered, particularly in the virtual environment. So there you go. You know, it makes it easier for people who are out of town or out of the country, for sure. Mm-hmm. And what was the other part of the question? I think I answered the virtual part, but what was the other part? Whether it was
what you find most challenging. Most challenging.
So I was going to say, so part of it is my own frustration. Like part of it really is just controlling my own interaction with people, because sometimes I do get frustrated with parties and their positions. Probably most mediators won't admit that, but I think they probably do as well. So part of it is just maintaining your presence and persevering. Like I'm usually, you know, part of it is just patience and perseverance throughout. So that's part of what I find sometimes challenging. You know, the other part of it, I think, is I don't like engaging with people's positions, because then it's challenging, right? I'm not going to argue with lawyers about their positions. So I think that's really like unproductive. So I think that you have to learn how to move around that. And so that's the challenging part. You know, it's very challenging if a lawyer doesn't really engage, has a position, sort of maintains it, doesn't give up much, doesn't communicate much, doesn't give you doesn't really engage so you get some insight into what's driving the litigation itself. So if the client's just there and silent, I don't find that very helpful. But I don't find that much of it that challenging or frustrating, because I like it. So.
I think this is going to be our last question for today, but what kind of advice do you have for people or for law students that are considering becoming a mediator? And what can students do now to prepare themselves for a career in mediation?
Well, I have a very specific view of that, because clearly students can go out and become mediators in all kinds of other contexts other than the court system. And they could be involved in nonprofits or in government, where the opportunity for being facilitators or mediators exists probably sooner. But I think if you're going to be classically a litigator in the civil justice system, I don't think you'll ever be a mediator unless you practice for 10 or 15 years to start, because people just won't come to you because you don't have the experience and the seasoning that they like to see in their mediators. So there's certainly that part of it. And I think the other thing I would say is that that for students who become lawyers and who practice, that the engagement in being a lawyer at a mediation, so just doing mediations from that perspective, getting more skillful as an advocate, being a creative negotiator, all of that is then transferable to being a mediator. So I think you just need to practice. I think most lawyers now will be doing that. They'll be probably doing a lot more negotiating than court appearances, probably a lot more attending at a mediation than court appearances. Nothing wrong with that. That's advocacy, and that's how you get the experience, and you're able to use your intellect and knowledge to develop the experience and judgment that's required ultimately probably to be a good mediator.
Amazing. Well, on behalf of the Mediation Clinic, we want to thank you, Leslie, so much for taking the time to chat with us today and to kind of tell us a little bit more about your experience and your work as a mediator.
Great, thanks. Thanks very much.
Thank you. Thank you all for watching. And thank you to Leslie Dizgun for joining us this evening.
If you have any more questions about mediation, you can always reach out to us at the Osgoode Mediation Clinic at osgoodemc@gmail.com or on Instagram at Osgoode Mediation Clinic.